Mr. Payne, the prosecution may call its first witness. The prosecution calls the defendant, Mr. Butt. The prosecution doesn't call the defendant. That's not how that works. The defense calls the defendant. Chief, what do I do now? Pay attention. You don't want to miss any information that might help your client's case. You'll get your chance to respond to the prosecution later, so be ready. Let's just hope he doesn't say anything unfortunate. There's also, no opening statements, no closing statements. Not everything actually needs opening statements or closing statements or submissions. Like in the Australian system, this doesn't appear to be a jury trial. So this isn't actually shocking to me that there's no opening or closing statements, because in Australia, submissions, especially when it's a trial just before a judge, would just be often done in writing. So that's not necessarily surprising to me. Just out of curiosity, would you consider doing a law show on here and some commentary? It depends. It would have to be like within my realm of knowledge. I am only a young lawyer. It would have to be not outside the realm of my expertise. But I know like Americans would go off on there's no opening or closing statement. Yeah, before in an Australian system, so much is done just in writing to save time. So a lot of so much of what is done in Australia is not done orally. It's often done in writing. This would be a bench trial. In Australia, yes, it probably would be, being a criminal trial. But the fact that it is being done before a judge, that is an option. You can just do cases just before a judge. I don't know if a murder trial would just be before a judge. Often, like, civil trials are just before a judge. Like, every case that I've done, I've not done a murder trial myself. Most civil, like, every civil case I've done has just been before a judge, obviously. I have been involved in sexual assault cases which have been before a jury. But yes, if it's just before a judge, which is being the case here, this is being presented as just being before a judge. There's no jury. In the Australian system, it is very common for when it's just before a judge, submissions are given not orally, but just in writing. So the fact that there's no opening and closing submissions, in the fiction of this universe, kind of makes sense to me that there's no opening and closing arguments. I can assume maybe they're just being given in writing. I don't know. I can kind of see that being the case here. I don't know. Maybe I'm giving the game too much credit. There's no opening and closing arguments. Maybe it's just being given in writing. Maybe. I don't know. Sometimes, yeah. I don't know. Sometimes... I don't know. I'd have to look into that. Sometimes, I know that there are times where it can be to your advantage, where you have the option of things being before a jury or before a judge, and it can be strategic to decide, well, do you want it to be before a jury or before just a judge? Oh, and also, just so you know, like, this murder just happened and is just before a judge. That never happens in Australia. Like, never. Like, in the fiction of this universe, murders happen and you go immediately before a judge. In no fucking universe does that happen in Australia. Cases take years. It doesn't matter if it's criminal or civil. My area of practice primarily has been, other than civil litigation, family law. Family law cases, if you were to like come to me and say, yeah, I want like a family law matter now, divorce would be immediate, because divorce is the easy part. Like, divorce I could get you done like in, let's say, 2 months. Divorces are immediate. The hardest part would just be serving the other party. Assuming if they don't want to be served. If you want like a resolution and it's going to be contested, if it's going to be contested and it's going to be a hearing about who gets full custody of the kids, and there's going to be like an argument about and you're not going to get consent orders. You're really disputing property distribution, and there's going to be an argument about property, and there's going to be an argument about kids. I could maybe get you like a final hearing in 2 years. That's how slow it is to get hearing dates at the moment in Australia. Or at least that it was, like, last time I checked. It may be even slower now because of COVID. Who fucking knows? So, yeah, if you think you're getting an immediate trial date, tell him he's dreaming. Uh-oh, Larry gets excited easily. This could be bad. So this is why the defense makes the decision about whether or not to put the defendant on the stand. The prosecution doesn't get to make that decision. Oftentimes, the defense will make the decision not to put the defendant on the stand because it could be devastating for their case to put the defendant on the stand because, I don't know, maybe the defense just has an untrustworthy face. It may have nothing to do with whether or not the defendant is innocent or guilty. The defendant could just have a completely untrustworthy looking face. They could just come off poorly on cross. Jury selection is a big thing. I have been involved in a jury selection sort of tangentially. Like, obviously I wasn't the one making the decision. I'm just a junior lawyer. But this was in the sexual assault case. Jury selection is important. You pick who you think is going to, and both the prosecution and defense get some say in who they want, who they think is going to be sympathetic to your client, who they think is going to be unsympathetic to your client. It is important, and that can also be part of why you maybe don't want a jury trial, maybe why you do want a jury trial, why you want a judge, why you want a jury. But yeah, why you put a defendant on the stand, why you don't put a defendant on the stand. Maybe your defendant just looks like shit. Maybe your defendant just comes off like a fucking asshole. And it could have absolutely nothing to do with whether or not they're innocent. So the defense makes the decision as to whether or not the defendant gives evidence. The prosecution has no right in a criminal matter to actually cross-examine the defendant. The prosecution has to make the case. The defendant does not have to make a case. The prosecution has to make a case. This is in criminal cases. Now, in civil cases, it's a bit different. Civil cases are done on the balance of probabilities. It's a much lower standard. So often in civil cases, both sides will give evidence because you're both trying to assert a version of events. It's not so much that in civil cases, generally speaking, both sides will assert a version of events because it's on the balance of probabilities. So you're trying to assert differing version of events. So it's more likely that the judge is going to try and work out, well, one side of events is more likely than another. That's just how it often works out, because on the balance of probabilities, what's more likely to have happened. That's just more often than not the manner of things, in my experience. It may not always be the case, but in civil cases, that's just what it is. So let me just give you an example of what I'm talking about. So let's say in like a civil case, you're saying one person is arguing that a contract was formed and another person is arguing that a contract wasn't formed. Well, if one person gives a version of events that I came up to you and I said I'd buy this, well then they've made out a version of events that a contract was formed, and another person says that's not what happened, they never walked up to me and said they'd buy this. Well, then it behooves both parties to tell their side of the story, because both sides are making out the elements of a case. If the judge only hears one side of the story, well then they kind of have to only go with they have to go with the side of the story they hear, right? They need to work out on the balance of probabilities what is more likely. So in a civil case, it behooves both parties to give evidence. In a criminal case, that's not what the same thing. In a criminal case, the prosecution has to make out the case that beyond a reasonable doubt, the defendant committed the crime. The burden of proof is entirely on the prosecution. The defendant does not have to make any kind of argument. There is no burden on the defendant to do it. The only time there is a burden of proof on the defendant is if they make a proactive defense. So there is only a burden of proof on the defendant if they say, for example, yes, I killed the person, but it was in self-defense. Then they have to establish that they meet the requirements of self-defense. That's the only time there is any kind of burden of proof on the defendant. So that's the only time there's any kind of burden of proof on the defendant, is if they make like a proactive defense. Otherwise, the prosecution has to say they have to actively prove all the elements of the crime and that the defendant did it. So that's why the defendant does not have to give evidence, as opposed to in a civil case where it's more likely that they will. Hope that makes sense. So that's why the prosecution can't like just call the defendant to the stand. Ahem. Mr. Butts, is it not true that the victim had dumped you recently? It's, okay. This is confusing. Because he's, as the prosecution, has called the defendant to give evidence in chief as if he's his witness. So, like, this is confusing. Hey, watch it, buddy. We were great together. We were Romeo and Juliet, Cleopatra and Mark Antony. Didn't they all die? I wasn't dumb. She just wasn't taking my phone calls or seeing me, ever. What's it to you, anyway? Mr. Butts, what you describe is generally what we mean by dumped. In fact, she had completely abandoned you and was seeing other men. That's not a question. She had just returned from overseas with one of them the day before the murder. That's not a question. Mr. Payne, you are not a witness. You cannot give evidence. Like, where is this in evidence? You can't... What do you mean, one of them? Lies, all of it, lies. I don't believe a word of it. Your Honor, the victim's passport. According to this, she was in Paris until the day before she died. Okay, like, again, there's just no discovery in this game. That is correct. The prosecution in Australia is the Crown. Yeah, so the Crown prosecutes cases in Australia. But I'm aware that this is not meant to be taking place in Australia, so I'm happy to just call them the prosecution. Indeed, she appears to have returned the day before the murder. Dude, no way! The victim was a model, but did not have a large income. It appears that she had several sugar daddies. Is this a question? Like, are you just... The prosecution is just giving evidence. Daddies! Sugar! Yes, older men who gave her money and gifts. Like, okay, so, like, the prosecution is just giving evidence. Like, sure. She took their money and used it to support their lifestyle. This is, nobody's raising an objection. We can clearly see what kind of woman this stone was. Okay, that's, wow. Wow. Okay, that's just, embarrassing. That just serves to embarrass... Wow. You can't just... You can't just make, like, assertions that serve no purpose but to embarrass the person. And, you know, this is that's an opinion, firstly. Again, you can't... that's not a question. And you can't just make assertions that serve no purpose but to cause, like, embarrassment and offense. You actually can't do that. Look, I mean, there have been, like, problems in the past where especially in sexual assault cases, where barristers would ask questions that serve no purpose but to raise like the sexual history of the victim. That has been a problem in the past, and they've tried to stop that somewhat. I'm not sure to what degree of success. I need to look into that law reform more. It has actually been a serious problem, but again, it's not like the barrister themselves like actually like making the statement. It's more them getting that information out of questioning. But that's like a submission. Yeah, it's just argumentative. It's biased. It's prejudicial. That's the word I'm looking for. It's prejudicial.
Tell me, Mr. Butts, what do you think of her now?
Okay, finally a question. But again, now, this is... Again, you finally got to a question, but like, this was like these have been like very... is he cross-examining, or is he doing initial examination? Because he is the prosecution, but he's called the defendant as his own witness? I'm very confused. Right. I don't think you want him to answer that question. Yeah, you should have objected a long time. You should have objected a long time ago. Where is my objection button? Yeah, Larry has a way of running his mouth in all the wrong directions. Should I wait and see what happens? Stop him from answering. Neither of these object. My client had no idea the victim was seeing other men. I mean, that's... you should have objected. But, I mean, that actually would be an objection. That's actually a valid point, though. Maybe... not what I would have done, but from, like, an argumentative standpoint, valid point. He didn't know any of this information at the time, so it couldn't have influenced his state of mind at the time of the murder. That question is irrelevant to this case. Yes, it is.
Oof, wins.
Dude, Nick, what do you mean irrelevant? That cheating I'm gonna die, I'm just gonna drop dead! Yeah, and when I meet her in the afterlife, I'm gonna get to the bottom of this! Your Honor, that question is devastating to my case! Let's continue with the trial, shall we? I believe the accused motive is clear to everyone. No, it wasn't. We've just established he didn't have the motive at the time of the murder. Yes, quite. Oh boy, this is not looking good. Again, that's a submission, not a question.
Next question. You went to the victim's apartment on the day of the murder, did you not?
Go. Well, did you or did you not? I mean, at least that's a question. But that's actually... Is that... yeah. Well, maybe I did and maybe I didn't. Uh-oh, he went... What do I do? Have him answer honestly. He should answer honestly. That's a fair question. I know, we'll send him a signal. Tell the truth. Yeah, I was there. I went. Well, Mr. Butts, dude, chill. She wasn't home, man. So, like, I didn't see her. Ah, see, I did his voice correctly.
Your Honor, the defendant is lying.
Lying?
The prosecution would like to call a witness who can prove Mr. Butts is lying.
So you're going to interrupt the witness in the middle of giving evidence to call another witness. See, this is why, you see, in the Australian system, everyone just gives affidavits first. I'd like to retittle of that rebuttal. Well, that simplifies matters. Who was your witness?
The man who found the victim's body,
just before making the gruesome discovery. Actually, this would have all been done by way of police statements first, because it's a criminal matter. So police statements would have been taken, and police statements would be evidence as well.
You saw the defendant fleeing the scene of the crime.
So police statements would be made available. So because it's a criminal matter as well, what would have happened first and foremost Yes, as I just said, immediately, everyone who is a person of interest would have given a police statement, and police statements would have been made available to, obviously, the prosecution, but also all relevant lawyers. The defense lawyer, myself, Phoenix Wright, would have received a copy of, the police statement of Larry Butts, who would have been interviewed. He would have taken a police statement. The witness who discovered the body, absolutely everyone relevant. So there would be police statements.